May I just answer some of the questions I was asked this morning that I couldn't answer? So far as general licences are concerned, there are no general licences to cover basic needs. There are general licences to cover legal services at a capped level.
At what level, sorry?
I will tell you. In addition, there are general licences to cover telecommunications and news media providers. And then there are...
Hang on, only for what? Legal services?
Legal services, telecommunications. So, covering your phone cost.
Yep.
News media. Your Sky subscription, I dare say. And then there are general licences dealing with company winding down. So there are various companies that have had to be wound down, and there's a general basic needs licence for them. The cap for legal services is 2 million.
So is it still the case that things like food
Aren't covered.
you have to ask for a specific licence?
Yes. You ask for a basic needs licence.
But how does that? So you go along after you've been designated and say, how am I going to eat?
Yes.
And they say, we'll think about it.
Well,
But the due course.
Slightly worse than that, because they say, what are you going to eat and how often, and give us a precise calculation. So it's incredibly convoluted. There's not even an automatic, oh yes, of course you've got to eat. There is a process of requiring very detailed.
But you put in a budget.
Yes.
What, on an annual basis, that I need to be able to spend so many £1,000 a year on my food?
Yes.
And they say, very well, you may do that. And what, then you go to your bank and say, I can draw down £1,000 now.
Yes.
Or 10,000 or whatever it is. And
the bank may or may not permit it.
Sorry?
The bank may or may not permit it, because there's an argument about whether.
Yes, but if the bank, I know all that, but the way it's meant to work is the bank will say, okay, that's fine, and will simply allow you to draw that amount from time to time.
Yes.
Until the moment when you have spent more than whatever it is, and then their systems will show that you spent too much.
I think it works month to month. So if you spent too much in 1 month, the bank won't let you have it, because they'll say, oh, you've already had your £2,000 this month.
You may have several licences. You'll have your have a licence to pay for your Sky or your online newspaper.
So in the appellant's case, she has a basic needs licence. She has an annual travel licence, although that's yet to be renewed. So it ran out at the end of last month, and so there's always a lag time in actually getting the licence. And she has licences for specific utility providers, although, as the evidence explains, that is not provided generally. You have to provide the specific number and then they'll license it, and they won't cover emergencies. You've got to have the emergency and then apply. So in her case, she got stuck in the lift, and then they won't let you have a contract to repair the lift. They'll just say, well, once you've been stuck, then you can apply to fix it.
Anyway, this is not a hearing about...
No. So economic resources, Your Lordship asked about that.
Yeah.
It's defined in section 60 of the Act. It effectively means an asset of any kind. Economic resource. Shall I just read it out, and Your Lordship will see? Economic resources means assets of every kind, whether tangible or intangible, movable or immovable, which are not funds but can be used to obtain funds, goods or services.
Yes, thank you.
And then Your Lordship also asked about whether it was the case that there was a preponderance of UK nationals under the sanctions regime, whether the players or the associates. And
well, I meant specifically
yes,
associates.
and the answer is not.
Well, I didn't actually ask about UK nationals. I asked about UK residents,
Yes.
I think.
So, in terms of people showing addresses, there are 46 non-pure associates, of whom 38 are outside the UK. And
I thought you were concerned with
I'll
pure
argue
associates.
pure. So pure is slightly complicated because there are company directors of designated companies who are treated as associates, but including them, which gives you the widest possible range of associates, there are 48 associates, including those company directors, of whom 21 are outside the UK, where we have addresses given. And we also have the...
Does that explain, the figure you gave before, you said the pure associates, there were about 20. And
yes,
Mr. Blundell said he was common ground that was broadly accurate. Well, in fact, I agree, out of a context of 1,500, it may not make very much difference, but in fact, if we're comparing like with like, there aren't 20, there are 48.
That's if you, yes.
Yeah, no, I'm not being picky. I just want to make sure we're looking at the same.
So yes, 48 is the widest possible number because
yes, it may be the company directors account for the difference, but we don't know. Okay, thank you.
We also have in hard copy form, the sanctions guidance. We haven't sent it to you electronically.
That's fine. I don't mind which form we have it in. Yeah.
You're happy to take it. Hard copy, then we have it here. 3.
Presumably the office, can I just ask this factual question, which I don't think will be contentious, the office, whose name is it Officy?
Officy, yes.
Didn't have to be created from scratch for the
The 2018 Act.
2018 Act. It existed because there were previous sanctions regimes which, in one form or another, had a licensing system.
Exactly. So the trend is you had originally, for a long time, UN sanctions and domestic, normally terrorist sanctions. Yep. Then it went to EU directive, and then when we came to leave the EU, it went to the 2018 Act, which is what we have now. So I was going to start with the proposition that the judge conducted a rationality analysis only, which leaves the question for your lordships to determine as to where the balance should be struck in this case. And the reason I say that is it is quite clear, especially from paragraph 36 of her judgment, that she relied upon Mrs Justice Garnham's analysis in Schvidler, which are all concerned with the judgment of the Secretary of State. And she herself, when she comes to conduct her overview of whether or not the balance has been struck so as to achieve proportionality, she also analyses the question as to, an example is paragraph 140, whether the Secretary of State was wrong and whether the Secretary of State, and she refers to the Secretary of State's
Sorry,
decision.
I got slightly behind.
No.
So
we start,
what you say, how do we see that's
you start with 36, where she's citing Mr Justice Garnham and Schvidler.
Yeah.
And indeed it runs through to 41. And then she starts her analysis of fair balance in relation to the issue effectively looking at the Secretary of State's decision making, as one can see.
Sorry, I'll be very slow. I'll speed up soon. which paragraphs?
So
I've got the 36 to 41
yes.
adopting Garnham.
So the next bit is the proportionality analysis, which begins at 136, but that is effectively an analysis of the submissions. But when you come to her conclusions, you can see that she is concluding not what she considers the right answer to be, but whether or not the Secretary of State has reached the right answer. And you can see that effectively at 151, where she's considering his decision on whether or not lesser measures are available. Section 2, again, considering what the Secretary of State's approach is. And her conclusion at 155, that the Secretary of State has not failed to strike a fair balance, makes it perfectly clear that although she is personally assessing the evidence, she's only using, and that's the point Mr. Blundell makes, she is personally assessing the evidence, but she's using it to reach a judgment on the rationality of the Secretary of State's decision, not to form her own decision.
Well, she's using it to review the Secretary of State's decision. I'm not sure I see that I'm not sure I see she's assessing it for rationality.
Well, my lord, she's looking at it only through the prism of the Secretary of State's eyes, and that does not suggest an individual judicial exercise. So every time she comes to an issue, she looks at it effectively from the point of view of the Secretary of State for the purpose of saying, is this a correct answer? So 152, she is looking at it, whether the Secretary of State is right, and she's looking at it for that purpose, ultimately in assessing not where she believes the fair balance.
Is that a fair summary of 152? 152 simply is addressing the question of the effect of what she calls the Secretary of State's approach. Which is the approach that you say, what approach is she there referring to?
She is referring to the approach to balancing, so that she's saying, well, the Secretary of State is effectively, as she says, able to reach a decision on the weight to be attached to sanctions other than where you might be, as she puts it, unpersoning the subject.
Hang on 1 second. I think what she's calling the Secretary of State's approach there is simply the approach to balance set out in the second half of paragraph 151. And she's calling it the Secretary of State's approach because she's meaning the approach for which Mr. Blundell, if it was he, was arguing. That's all that means, isn't it?
All of these paragraphs from 149 onwards could be scrutinised and could be criticised against, or it could be said against me. She's not saying explicitly that she's considering the rationality of the Secretary of State's approach, but that I would make two overarching points. She never says, I am striking the balance. This is my assessment of where I consider the balance lies. It is always considered by reference to the Secretary of State's decision. And as I say, in 155, she says, in terms, the Secretary of State...
Yeah, the 155 is your best point verbally, I'd have thought.
And the silence as to her own individual conclusion. Because she, I mean, otherwise, why has she cited Mr. Justice Garnham in Fiddler in the way she did? That's quite clearly guiding her approach. And in the absence of some clear indication, as required in, according to the Dalston analysis, that she has recognised as requiring judicial decision the question of fair balance, which she nowhere articulates. There's every reason to suppose she's fallen into the familiar trap that by speaking of the Secretary of State being the primary decision maker whose views must be given weight, she's fallen into the trap my Lord Justice Singh identified of assuming that that in some way spared her the task of performing a judicial assessment of that balance.
It's certainly striking that she doesn't say, having recited Mr Justice Garnham's approach, which we now know with hindsight, but perhaps a public lawyer might have known at the time, is wrongly stated. Although Mr Justice Garnham says this, was it submitted to him to her that Mr Justice Garnham's approach was wrong?
It was certainly submitted to her that it was a judicial task. I can't remember whether I specifically addressed Mr Justice Garnham's decision. I suspect I did, but I can't remember. We've got a transcript, so somebody will be able to dig it out, but I'm absolutely confident that I will say it is a judicial task to determine the question of proportionality.
In fairness to you, can I just point out what I said in Dalston, in particular paragraph 19?
My Lord, yes. So 980 behind flag 23.
Exactly, yes. Just so that you can address the point. I made the point that the court never has the role of being the primary decision maker, because its function is still one of reviewing the decision of the public authority concerned.
Yes. But it is of making a judgment as to where the balance has been struck.
Yeah, the first sentence of paragraph 20 makes that clear.
Yeah.
The standard of review is not the rationality standard. But all I'm giving you the opportunity to address is that simply because a court says, I have reviewed the legality of the Secretary of State's decision and I don't find it to be wrong or unlawful, that doesn't necessarily mean that they've applied the rationality standard.
No, but it doesn't necessarily mean they've applied any individual judicial scrutiny to it either. And certainly on appeal, I would respectfully submit that this court ought to be satisfied that there has been individual scrutiny if it's to say this is a category 3 case where we've got to be persuaded it's wrong. So I can't say any more about it than that. It does not emerge clearly in my submission from the judgment. But even if your lordship is satisfied that sub silentio this was nevertheless an appropriate...
Sorry, just to my note, you said you were making two overarching
Yes.
points. The first was that she never said that she was striking the balance.
Yes.
Then various points were made after. I wasn't sure what the second one was.
That effectively she was
Following Schvidler, I guess.
following Schvidler, yes.
Yeah.
There's-
Okay, thank you.
So in any event, even if it is a category 3 case, that is one where the court must be satisfied the decision is wrong. In our submission, it is plainly wrong for the three reasons I flagged before we broke. Firstly, the approach to the weight to be accorded to the virtue of sanctions on one side of the balance was inappropriately heavy on her analysis and should not have focused on the virtue of the sanctions regime as a whole, but rather specifically on the virtue and effect of this sanctions decision in this case. Secondly, I'm going to say something briefly about primary interest of children, and then I'm just going to deal, I hope equally briefly, with the balance, looking particularly at the personal side in this case. Can I, though, start with the actual decision-making in this case, because it is illuminating to this extent that it demonstrates that the Secretary of State and indeed Mr. Reid, who supplements the reasoning, in a way I would have said violated Ermakov, but we are where we are. But on either of those analyses, there is no proper approach demonstrated to assessing the weight in favour of the sanctions regime in any of the material we've been given. So,
sorry, you've made obliquely and in passing an Ermakov criticism.
Yes.
Did you make that
I did make that
complaint below?
Yes, I did.
Yeah, and it was rejected by the judge.
Well, the judge effectively says, found that was not part of the reasoning. You can see that, I think it's around paragraph 90 odd, where she says, by reference to the reasoning, that it was originally confined to sending a message to Mrs. Khan and to the government. You've got that, it's 95. So her analysis at 95 is based on the Secretary of State's reasoning. And then at 96, she refers to, without the logical corollaries that only find real expression in Mr. Reid's case, evidence. And that, the background to that is the Ermakov submission that Mr. Reid had added the influence on Mr. Khan as having been a motivating reason. So, I mean, there is, if it's a good point, there is an Ermakov point there, but I'm content to deal with the case on the basis that if your lordships are striking the balance now, you're bound to take into account Mr. Reid's evidence insofar as it illuminates your own decision as to what weight the sanctions regime should bear in the balance. And it's certainly only in Mr. Reid's evidence that you get, even faintly, the suggestion that this is not just about pressure on the appellant to do something. It may also be pressure on Mr. Khan to do something of his own motion, and that the first time that's mentioned is in Mr. Reid. But just so the court has the references, the clearest explanation of the reasoning is in the sanctions designation form, and I can take the version that's in bundle B. Pine flag 13.
Any particular reason why you're doing that? Because we've got it in both forms, and when I've marked
Oh, well, I can take it in X, that's
well,
fine.
it's quite useful to see, because I think it's quite heavily redacted.
It is, but actually the redactions are redactions in any event, which...
Oh, I see. Well, look,
no, I'll take it for,
if you don't mind,
No,
but we will have to be careful what we say aloud, but that's
Yeah.
what I've marked up myself.
So flag 4 in X. And the first part of the relevant reasoning comes at the 150, because that first part is concerned with the criteria. So you can see just before the midway point, this first section is concerned with whether or not she meets the criteria. And then the second part, which is the proportionality assessment, which is where one would expect to see some consideration, individualised consideration of the effect of these particular sanctions. You see virtually nothing. So what you get is a 151, you get a generic consideration of the objective as encouraging Russia to cease its actions in Ukraine. That's just above halfway. You then get a consideration of the extent to which there's a rational connection, and they say, just by the second hole punch, the measures send a strong political message to Mrs Khan, the government of Russia and the international community, and it may incentivise the government of Russia to change its behaviour. And then the top of the next page, 152, the point is made that Mrs Khan is an associated person, and there's reference.
Where does it?
Just
before I see. Yes, I see. No,
yeah.
It's so right. Yeah,
Yeah.
yeah. So this further redaction is presumably privileged.
It is government redaction, yes. Yeah. And then, after considering whether a less intrusive measure could achieve the effects, and the conclusion that they couldn't, although frankly one would have expected them to identify effects in the earlier part, they then say, so far as fair balance is concerned, over the page at 153, effectively that by the first hole punch, designation will have an effect on dependents. They refer to the mitigation in the next paragraph, the mitigation that's available from the National Health Service. And
sorry, I may have created difficulty by insisting we look at the unredacted version, but
those are also government redactions.
but sorry, which paras are we on?
So I was just referring to the second full paragraph. We understand Ms Khan,
Yeah.
and that 4 lines into that, recognising impact on the dependents. I'm doing this now because it saves me coming back. Next line, next paragraph, recognising impact on access to healthcare with the ameliorating factor of the NHS and licences. The next paragraph dealing with basic activities, and then
Yes, it's no doubt it's just template language, but may also impact is a bit weak. Well, obviously, gravely impact is what it ought to say.
it's extraordinary at this stage, because this is the review. This is after they've had the evidence of exactly how damaging it's been. One could understand the original decision. They didn't even know she had dependents.
Yes, no, I know, but they do now.
They do now.
And they had, we've got the details, you need to soon have, we got, that basically they had plenty of evidence, but they had a dossier put in front of them.
Yeah, exactly.
Yes, so the language is surprising, isn't it? May impact.
It is. And as is the conclusion, I would respectfully submit that the licences for healthcare and so on, which is the next paragraph, were mitigated to a sufficient degree to render the designation proportionate, given the importance of the objectives being pursued. And that's really the first time where they identify the objectives, and they are identified again by reference only, right at the bottom of the page, dealing with reputation and saying, given the importance of the objectives. And accordingly, one is driven to the conclusion that they take the generic objective of encouraging Russia to cease destabilising Ukraine, and they simply assume that it should be weighed against the harms that are being caused in that monolithic way. And there is no sign of any consideration being given to the effect, in practical terms, in support of that objective at all. Now, I certainly accept that Mr. Reid does go further, and it may be that I don't need to do anything more than tell your lordships where it is, but he does go further, as the judge observes, in assessing what effect the designation may have, really at 208 and 209.
Shall we look at that now
Yes,
or later?
if your lordship doesn't mind. Sorry, I'll give you. Do you want it next? I can do that.
Sorry, we
Three.
probably marked up different
No.
numbers. I looked at it in X, yes, where is it?
It's absolutely not a problem. 333 in X. Yeah. Okay, and it's paragraph 72. And this is the most detailed consideration of what is said to be the likely effects, which on my respectful reading of it are no more than unlikely.
Well, some of them don't. I don't understand. Designating her will send her a signal, and to others. That there are negative consequences in receiving her.
Yes.
I mean,
And that,
so I mean, it will, but how does that contribute?
and indeed that associated persons bear some personal responsibility.
Yes, in fact, you're right. That's actually more the one that I was. For the consequences of activities which have provided them with finance. Well, have they?
Well, not on any detailed analysis of the case against Gaman Khan. I mean, on the face of it.
The financial material benefit they have had is money from Mr. Khan.
Exactly.
And they bear some personal responsibility for the consequences of his activities that provided them with the money. But did his activities weren't prohibited activities, were
No. And indeed, as I pointed out, his business activities start in the 90s.
Anyway,
So,
that's
anyway.
A.
B is to disincentivise her from continuing to obtain financial benefit, which is extraordinary. He is himself subject to sanctions, and she has shown no signs of being inclined to act criminally by obtaining money from him. And then there is dissuading others.
Hang on one second. Yes, go on, yeah.
Dissuading others from, in the future, obtaining benefits from sanctioned individuals, which again is quite hard to understand, given they are sanctioned. and reduce the benefits they, that is presumably again Mr. Khan, can gain from their positions. It is quite hard to understand. Given any application of an ordinary understanding of human behaviour, how these benefits would flow. So C is the closest you get to anything rational, which is encourage her to put pressure on her husband in the hope of sanctions being lifted. And the point my lord made just before lunch, at the top of 334, Dingemans Khan may also be incentivised to act on his own initiative and change his behaviour in the hope that sanctions would be lifted.
This is all in the section of his witness statement where he's setting out rational connections.
Yes. Yes. And contribution to achieving purpose.
In my judgment in Dalston projects, I say that the question of whether there is a rational connection or not is an objective question for the court to decide.
Yes.
So as long as there is something that is a rational connection, then what is the difficulty as a matter of law?
None. I'm taking you here because there's no. This is where you get the counterweight to the personal interest in the fair balance. This is the only place where you get it.
I see. So he doesn't.
And
do
so
that.
if you have a completely capricious and irrational description of how the counterweight works, then you are not entitled to say, as the judge did, oh, sanctions are a really good thing, we need them to stop Russia behaving. When you come to do your individualised balance, that is not permitted. What you have to do when you come to do your individualised balance is say, of course sanctions are a good thing, but what's the effect of these sanctions going to be? And if the only explanation I have is a completely incoherent and, frankly, unreasoned analysis of what good it might do, that will carry very little weight in the balance. So I accept my Lord's point about the label, but this is the only point where you get how they say it has any effect that ought to carry weight. So the last...
Because I think in the fair balance section, starts at 76, it's all about the impact on her, and it takes what goes into the opposite balance for granted.
Exactly.
In practice,
exactly,
as previously stated. Yeah.
So it's exactly the same approach as you see in the sanctions designation form. They just assume sanctions are a good thing and that it's going to send messages without saying what the effect of that will be. And then they go immediately to saying, well, given that sanctions are for the benefit of the community, what's she got that outweighs it? And that's simply wrong.
Your essential point is that in the balancing exercise, both sides of the balance must be individual.
Yes.
Obviously, the detriment is individual.
Yes.
But you also say that the advantage to the promotion of the government's purpose must also be individual and specific to the particular case. And that's not the same as you're not taking the cumulative debate.
No, exactly not. No. And that's why I was at such pains to say that the associate category is quite different from the connected to Russian shipping category, because you can see.
I'm just reminding myself of what Mabott says about Lim 4, the fair balance test, and if it helps you, I summarised it at paragraph 9 of my judgment in Dalston. And it may be important for us to recall that the way in which certainly Lord Reid summarised Lim 4 is whether the measure's contribution to the objective outweighs the effect on the rights of those to whom it applies.
Yes.
On your submission, in that sentence, does measure mean the individual?
Application of the measure to this person.
Yeah, I think
Yes.
that's. I had that point in mind. I got it wrong when I asked you what measure meant
Yes.
in Lord Sumption's
Yes.
statement in Gallagher. But here you say measure means the actual decision.
Undoubtedly. The application of the measure to the person.
I think that is how, subject to further submission, I think that's how Lord Reed is using that term, because earlier against letter C, I summarised his reasoning as being limb 1 is whether the objective of the measure
Yes.
is sufficiently
Yes.
important. So I think what you're saying, if I've understood you correctly, is that at limb 1, you're entitled to, and indeed you should look at, the generic
Yes.
object.
A high level of abstraction.
High level of abstraction. But when it comes to limb 4 and the balancing exercise, what you're putting into one side of the balance is not the high level abstract objective, but the measure's contribution.
Correct.
To the
To that objective.
Right, I see.
Well, is that how Lord Sumption put it when he talked about striking the fair balance between the rights of the individual and the interests of the community?
It depends. So, Lord Sumption, as I said, proportionality features both at a generic level.
Yeah.
If there's an ab ante challenge, where you would put the full force of the generically of the measure against whether or not it was going to be proportionate in all or most. And then separately, when you come down to the individual impact, then you are looking at the measure as applied. And the balance has to reflect the measure, the effect of the measure as applied, in this case, as against the individual harm. Otherwise, you'd simply never have, other than the most extreme case of, say, death or torture, you would never win a fair balance case.
And what do you say about D? I think you were about to.
So D, there's simply no evidence of that would begin to suggest that the appellant would have permitted Mr. Khan to use her as a means of circumventing the restrictions. On the contrary, her behaviour has been only consistent with the greatest possible transparency with the authorities. And in any event, if one's treating that as being a serious contention, one would expect to see some evidence that was.
If you, I'm just thinking about, if you are right that the judge approached this in the wrong way, and we've got to strike the balance ourselves, though in practice we might have to do this anyway, but because of your fallback solution. But assuming that we're starting from scratch, do you say effectively the exercise for us is an exact critical examination of the impacts on her, which are undisputed effectively,
Yes.
and the justification
Yes.
in para 72 of Reed?
Yes, but I make that concession.
Subject to your Ermakov point.
Well, subject to the Ermakov point, obviously, but I have to recognise that if I'm asking the court to make a judgment now, I can't ignore Mr. Reed.
Ermakov is to do with domestic.
No,
Yes, Ermakov is really.
I accept that. I mean, it's perhaps no more than a jury point, but it didn't occur to anyone until we got to Mr. Reed that that was the real purpose of it, to put pressure on Mr. Carr.
Yes. I mean, in all sorts of. I'm rather assuming that this sort of what applies here is the general rule in convention cases that, in principle, the government can advance an ex post facto justification, though the fact that it is only ex post facto may make you sceptical about it. But that's the right approach, isn't it?
But there are two important consequences of the way in which I submit you should approach the weight to be given to the effect of this designation, the government side of the balance. It is not only do I submit that you should consider that the government side of the balance on an individualised basis, but you also need to consider it, and this is to my advantage now, and determine whether or not, as we stand now, there's any sign. So it's no longer a predictive exercise. We're 2 years in to this process of these sanctions having been applied. You are entitled to treat with some scepticism a claim that there remains significant virtue in the government side of the balance, not least because there is no special competence possessed by the government in terms of the sort of human psychological calculations they're making in their analysis of what may be a positive effect of the action they're taking. So none of the Reed reasoning is cloaked by the special competence that might be associated with predicting what, if we take Carlyle, precisely how the government of Iran might react to Mrs Rajavi coming here to speak to the Parliament. That is an area I recognise as special competence. But if you're looking at the sort of areas that Mr Reed is speaking of,
in Para 72?
In Para 72, the court's in an equally good position to make assessments and judgments of ordinary human behaviour in circumstances of government pressure. And therefore there's no reason for the court to defer in any significant way to the assessment of weight made by the Secretary of State. So if one looks at the way in which the judge effectively approached this, it was to say, essentially, the government side of the balance was, as she put it, a purpose of the highest importance, about as heavy as it can be. And at 151, she describes this as having to be weighed as an indivisible part of the whole. And that, in my submission, is to render effectively immune from analysis by the court a decision which, in fact, it should be directly grappling with.
So it should be?
Grappling with directly. And that's for the two reasons I've given. Firstly, the anti-Carlyle point, that the particular reasons relied upon are capable of being independently assessed by the court. And secondly, the Ahmed point, and I'm conscious I haven't taken you to Ahmed, but the Ahmed point that it's precisely this type of decision that ought to be under judicial control, which means not just the decision is taken by the court, but the components are identified and weighed by the court. So the judge is wrong in giving the government side weight. I'm turning now to deal with the interests of the children very briefly. Neither the Secretary of State nor the judge refer to the children as being a primary consideration. Both of them refer to the family, I accept that, but there is no indication of any attempt to apply the law as it was outlined in HH. And your lordships have got HH, I don't need to go to it for long, but it is volume 2 behind flag 11. the interests of children is first broached as a matter of principle at paragraph 11 at 438. Where Baroness Hale, at the bottom of that page, paragraph 11, says, where a decision directly affects the child's upbringing, such as the decision to separate the child from her parents.
Just remind me, though, I'm very familiar with this in the immigration context, where it comes in because it's in the Borders Control Immigration Act. This is just an unincorporated. If it's the United Nations Convention on the Rights of the Child, is HH authority for saying that it must be borne in mind in that context?
It's authority for the proposition that it must be borne in mind.
Simply because of the International Convention?
No, it's because human rights grounds are a defence in extradition proceedings, and therefore there's specific requirement to consider the contents of Article 8, and certainly...
I see that. Well, we're concerned with Article 8 here too.
Yes, exactly.
But I just wasn't sure what was the legal route by which the primary, the fact that the best interest of the child to be a primary consideration comes in.
It's because it's part of the proportionality assessment, paragraph 12.
If you look at paragraph 2, the certified question from the Administrative Court raised Article 8 and the different approaches that have been taken by the Supreme Court and then asked for a decision. So it came in straight through Article 8, which, as you rightly point out, is referred to as a ground on which extradition can be resisted.
And it's paragraph 12 says in terms that it best interest of the children, a child must be a primary consideration in an Article 8 proportionality assessment.
Okay.
Sorry, where is that a quotation from?
That, I believe, is a quotation from ZH, but I would have to check.
No, I think it's from the Australian case.
Yeah, that's what I thought. But anyway, it receives the imprimatur.
Yeah, it does. It does, and certainly if it's...
It's a bit odd. Why is an Australian court talking about Article 8?
I think it's a reference back to her judgment in 2011.
Yes, which would be ZH.
Yes, yeah.
But in any event, I don't believe I need to struggle, because the conclusion of the court, to which everyone agrees, is effectively at paragraph 33. Where she's dealt with the issue, as my Lord Justice Dingemans says, about whether you need exceptional circumstances, which is where the division had occurred. And she says you don't need exceptional circumstances because, and this is an E, Article 8 has to be interpreted in such a way that that's children's best interests are a primary consideration, although not always the only primary consideration.
No, thank you. Well, that's answered my question.
So one can see that it simply never features as a primary consideration in the original decision, because they didn't even know she had children. In the decision I've shown you, because their treatment is treated as being really to be equated with her treatment, and all ameliorated by the OFSI licensing regime, and certainly no sign of the conclusion that one would have been bound to reach if you did say what as the primary consideration of the interests of, let's say, the 9-year-old, he's now 12. What do the primary interests of the 12-year-old involve? And
Well, that all rather depends what the off-sea licensing regime allows them to do.
well, your lordship saw an example this morning. It allows him to become, as a result of the sanctions, seriously psychiatrically unwell, where the off-sea regime is unwilling to concede any need to ameliorate the regime other than provide psychiatric treatment if an application is made. There was nothing wrong with this 9-year-old before his father was prevented from coming to the UK and before his mother was sanctioned.
Well, it was the sanctioning of the father that,
Yes.
if you read through the,
Yes,
detail
no,
of the evidence, and there's no
yes.
challenge to the sanctioning of the father. So I think I mean, if you look carefully at some of the evidence, I'm not sure it necessarily supports what you say in relation to the mother. Obviously, then there are different issues that are raised because the children's interest then does take part of hers.
Yes.
The youngest child is now abroad in any event.
He is, although it is not intended that should be permanent. There's no intent that the family should be permanently split.
No.
And the other 3 children are all here. And that is one of the really pressing concerns, if I can say this, of the appellant, that at the moment she's in a position where she has to care for the 12-year-old, he's 12 after all, can't just abandon him, but all her other children and grandchildren are here and will remain here.
In extradition appeals, and one doesn't necessarily welcome it, we always get updating statements because we're reviewing the exercise and we are primary decision makers on that. There's nothing updating that. I mean, it's obviously common ground between you that the child's in Moscow, but we can't get it from any of the evidence before us.
You can't, and indeed, as I say, I was not conscious of the need to provide an updating statement. We are in a position to do that, but
No, I did. It's not encouraging it at all.
no. But I thought it right to make it clear that he was no longer situated as the judge described in the state school that he has. But I mean, apart from anything else, that's because Mrs. Khan can't pay for a nanny. I suppose she could apply to officer. I'm sure I know what the answer would be. So the 12-year-old has to go with her. If she goes to Moscow to sit with her mother who's having chemotherapy, she can't just say, "Oh, bye, darling, see you in a couple of months." And so he has had to move in any event. It is a nightmare scenario that they will be stuck where they are, particularly if they don't yet have their annual travel licence. They don't have the money to fly back, fly him back. Anyway. But it's a very simple point. If I had to persuade the court that the decision was wrong, a failure to take into account a clearly relevant consideration.
This is the judge's decision.
Yes. Yes. So I'm assuming you're against me on whether she made her own assessment.
Was this submission about the best interests of a child and the HH case?
Yes.
Was this advanced before the judge?
It was. It arose by a side wind because the submission was made by the Secretary of State that the sanctions obligation was one that took colour from the fact that there were international obligations as a result of international agreement to operate a sanctions regime, and therefore it had to be given weight because it was the subject of international obligation. And my response to that was, not so. Look at HH, it's exactly the same balance. So in HH, the balance is international obligation under extradition arrangements to extradite, but you still have to consider best interest of the children. So that's how it came in.
Can I just come back to a point I put to you earlier? The best interest of the children, certainly the primary point,
Yes.
concerns the access to health care and to private education of 2 of the children. One child.
One now. one.
Health for one and private education.
Now one, because the second son, who was 16, is now 19.
It's we'll stick with
Yeah.
the essential point. If the officy regime, you say it doesn't, but if the officy regime allowed what your client would regard as satisfactory health care, and allowed the child to continue at the stool he was at before and not have to change stools. And the Secretary of State, well, sorry, if they allowed that, there wouldn't be a particular problem. Of course, there would be a problem they were separated from their father, but that's not the result of this designation. So it is only the operation of the officy regime which you say makes this disproportionate in this respect.
Not only, but it certainly accentuates the disproportion. So
But what I think is said by Mr. Blundell is, well, the fact that individual bad decisions may be taken under the officy regime is not a reason for non-designation. There is a system there which is designed to mitigate, mitigate a bit of an understatement, but mitigate the harm done by having all your assets frozen. The Secretary of State, knowing that there is that system in place and being entitled to trust it to make fair decisions, there is no harm from his decision to the children.
well, can I just provide a number of answers?
Yes.
But
please.
firstly, the decision, for example, on schooling, as you can see from the letter I handed in today, is based fair and square on the officy guidance. They quote their general guidance as being the basis for saying, for example, this is not an extraordinary situation because they regard the child's psychiatric condition as neither being unusual or remarkable.
Yes. So yeah, go on, yeah.
So even if one says, well, one can expect humane decisions, they are bound by the guidance that they have, which appear to pay very little attention to humanity and much more to determining that as little as possible should be provided to the designated person. Secondly, there will be immense harm even with the most benign licensing arrangement, because the whole fact of sanctioning cuts into the social functioning of the appellant and her family. You can all sorts of basic activities, like going out to lunch with your daughter, for example. Daughter's not sanctioned, but she can't buy Mrs. Khan lunch because that's an offence. And so it doesn't require very much.
I saw why that was so, but remind me which regulation?
It's making making funds available to take, potentially. It is making funds available for her to enjoy. Now, I accept that you may say, oh, well, they won't prosecute, or you may even say that's not an offence. But the reality is that they all live their lives in the, I would say, rational fear that they will commit some offence and therefore they cannot go about their ordinary activities in any way.
Right, this is stepping. I understand this point. I'm not saying it may not be important, but I'm slipping away from the rather particular point about the impact on the children, and the particular points you were making about impact on education,
yes.
Impact on health. And I was saying that the answer to that, advanced by the Secretary of State, is all that can be dealt with by a humane officy regime, Secretary of State is entitled to accept, to proceed on the basis that it will be humane. If it's not humane in any particular cases, well, you'll have to challenge those decisions or those aspects of the guidance. What's your answer to that?
That is not the situation that is in fact being presented to the Secretary of State for him to strike the balance, or for the court to strike the balance. He had very detailed evidence demonstrating that there was no...
You're quite right to pick me up and see how easy it is to fall into this error. The court striking the balance is entitled to say that the designation was not unlawful because it was coupled with an off-sea regime which gave the capacity for the impact on the children to be removed, any serious impact. And the fact that in these particular cases it didn't is regrettable, may mean those decisions have to be challenged, but does not mean that the designation was wrong.
If what the court is doing is valuing in the balance some future amended regime rather than the reality that faces the family, then that, in my respectful submission, is not a way in which to strike the balance. The fair balance is not an idealised analysis of where the various interest lies. It is the gritty reality of what actually happens in real life.
I understand that, but although you're quite right, the balance is for the court, not for the Secretary of State, it is the court reviewing the actual decision made in the circumstances applying at the time of the decision. The time of the decision, if the court was standing over the Secretary of State's shoulder and saying, before you designate Mr. Khan, what about the impact on the, or continue to designate, so we're talking about the review decision, what about the impact on the children? I suppose you would say at the time of the review decision, some obviously problems had already arisen.
Absolutely. So the detailed evidence about the across the board difficulties caused by the Officy regime was fully in front of the Secretary of State.
Yes, I see. Not at the moment of the original designation.
No.
But at the moment of the review decision.
They were a year down the track, so there was a year's worth of history. So the Secretary of State simply wouldn't have been able to say, there's nothing on your side of the balance because we will in future operate the system perfectly, because that would not be a legitimate factual conclusion, given that all the evidence of how it actually operated in practice pointed the other way.
Sorry. Thank you. I see how you put it. But it is right, and it's implicit in your this part of your submission by the emphasis on the children. The real target is the way the Officy regime works. Because if it worked in a different way, as you put it, a humane way, the matters which you complain would not arise. But you say in the real world, that isn't the way it works.
It's that, and there would still be the hardship caused by being subject to even the most benign regime of sanctions. I mean, that Ahmed.
All right, but you're slipping away again from the children point. I don't mind. Move on to a different point.
No. The children is a very strong counterbalance to any claim to give weight to the government side of the balance. But it's not the only weight that counterbalances the government's case.
Yeah, okay.
So perhaps if I just turn and I've said how little weight the government side has. I can't add to that, I don't think. But even if one assumes a working Ofsted system, you still have on the personal side of the balance the fact that this is a designation made against someone who is utterly blameless and effectively powerless to change the position. So there is no hope of them escaping the position they're in. It is a woman who has, and again I'm not going to go into the confidential detail, but a woman who herself and her family have demonstrated as clearly as they could by examples that we give that they are supporters of the Ukrainian side of this conflict, and they do not in any way condone or support the actions of the Russian government. And in my submission, again, even on the assumption that you have a perfectly working Ofsted system, the fact is that almost every way in which ordinary life is lived, whether it's getting the tube or buying food or paying your utility bills, every part of it is affected by the fact that you have to ask the state for permission. And even when you get a broad permission, every year it's got to be renewed, and some years it's not renewed. As I said, travel has yet to be renewed. And so the prisoners of the state remark that one has in Ahmed describing the impact on people who are subject to sanctions, it is true. Even with a perfect system, Mrs. Khan has to seek permission for any expenditure on any part of her or the dependent children's lives.
Ms. Montgomery, I ought to know this, but I forgot, I'm afraid. In the Ahmed regime,
Yes.
Was the person who was actually designated the person who was on the UN sanctions list, or could it also be an associate of that person?
So it could be an associate, and it was one of the issues was the degree of the intensity of focus in associate cases, and there's a long passage in Lord Mance's judgment where he deals specifically with the question of association, which actually might just be worth me showing the court. So Ahmed is in volume 1, line flag 9. And the passage in Lord Mance he describes the restrictions at 388, paragraph 246.
Page 388.
388, my lord, 246, dealing with the issue of access to the court, and explains that G and HAY are on the list of persons associated with Al-Qaeda.
Yes.
And then he makes some comments about the position of heads of state at 247. And at 248, he says, between D and E, there's a relevant distinction between measures directed at states or their acknowledged heads or alter egos, and on the other hand, measures directed to, in entirely general terms, to anyone associated with such actors. And he explains how the terrorism order works. And then he says, just below G, designation as an associate of a rogue state or non-state organisation under the resolutions and the consequential freezing of assets has radical consequences for personal and family life. It is a matter which one would expect to be subject to judicial control both before and after the designation.
I fear I didn't make my question entirely clear. I understand the word associate was used there, but that's being used in the context of associate of a rogue state or non-state organisation. But my client was Mr. G.
Yes.
As I recall. He was on a UN list.
Yes.
What the real question I'm asking is whether in that sanction regime you could also designate Mrs. G. It was a draconian regime. I fully acknowledge that because it undoubtedly had an impact on, for example, his family.
Yes.
I remember having to tell their lordships that they had to produce their shopping lists.
Yes.
That every receipt for food had to be shown to civil servants, things of that sort. So I don't discount that it was a very draconian regime.
Yes.
But what I can't remember is whether you could actually designate the spouse.
You could, as I understand the passage, so now I understand the question, 314 paragraph 4 sets out the designation, and it appears that the reason that the spouses were affected was because there was an issue as to whether or not they could, the clients, G and HAY, weren't entitled to benefits, but their wives were. Right. And the issue was whether or not the spouses could make any payment that had the effect of providing food for G or HAY. And so that was the impact, which I understand is being described there, which is why they say it affects third parties. Because it concerns the payment of social security benefits. And that was subject to a regime for approvals. I'm just trying to trace down where it's dealt with, but it's clear that system, so 38, paragraph 38, 326. Deals with the way in which payments of basic living expenses was permitted.
Even now, we haven't quite got to the bottom whether you could designate spouses as such, but what we have established is that they hadn't done in that case.
They haven't done in that case.
Sorry, just before we leave the OFC question, as I understand it, the whole licensing regime is provided for in Part 7 of the regulations. Is that right? I've seen a reference to Part 7,
yes.
but we haven't got it.
We will get you all the. I'll make sure you have electronic.
But that's where one will find it, because the guidance itself talks about the legislation,
yes.
but it means the second legislation.
Yes.
Yeah. Thank you.
So just three short points. In my submission, the decision on proportionality needs to be made on the facts as they existed at the time of the decision making, not in relation to some future better regime. Secondly, the government side of the balance has to be considered on an individualised basis. And there is nothing there that falls within an area of special competence that the court isn't able to assess for itself. And there's certainly nothing to suggest there is any likelihood of any real effect. Certainly not now. And then thirdly, the effect of being, I'll take the armoured phrase, a prisoner of the state, is deeply damaging. It's damaging to the appellant just as much as it is to the children. And that damage is, again, to use the language in Ahmed, remorseless and devastating. And on any view, it is wholly disproportionate to the effect that might be hoped to be achieved by designating the appellant. Can I just deal briefly with the point on which leave is sought? Because it may be that if the court is inclined to accept the way in which I submit the question of balance should be approached, there is no difficulty. Section 38, if it is to be read in that way, does provide a remedy where, as it was put by Lord Mance, there is judicial control both before, during and after somebody is designated. The only reason we raise it is if the court is driven to the conclusion that, whether by reason of a doctrine of deference or because it's impossible for the court to contradict the claimed weight that the Secretary of State identifies as being in the government side of the balance, then we would submit that would not be a sufficient court-based control to satisfy the requirements of Article 6. Now, I have to face the fact that I did not argue this below, and that there is a decision by Mr Justice Garnham in Yusuf where he says in terms that the Section 38 judicial review remedy reflects a sufficient protection to meet the requirements of Article 6, and even if it doesn't, he says it's provided for by a statute, and therefore, insofar as it can be regarded as making inroads into the right of access to the court, that has been the subject of statutory authority. I think all I need to say is that we do respectfully submit Mr Justice Garnham's wrong, and he's wrong because the regime he was commenting on, the Samla regime, in the case of Yusuf, who was the subject of Security Council designation, was exactly the same regime as had been considered by the Supreme Court in Ahmed and held to fail the tests, whether they were expressed as common law test of right of access to the court or whether they were expressed in terms of Article 6 of that right. So far as Ahmed was concerned, each of the judges who gave judgments on this issue said a judicial review remedy is not sufficient to meet either common law or Article 6 obligations because the court is not able through that review to do anything about the Security Council's designation other than make representations to it. And not only is that the way in which the court expresses itself, it's the reason they allow the appeal, because the Court of Appeal, my Lord Justice Singh may remember this, the Court of Appeal had said, oh, there's sufficient access to the court because you have a JR right, and the JR right may result in the court telling the Secretary of State he has to make representations to the Security Council, and that's sufficient. And so it is the ratio of armoured in the Supreme Court that is not enough. And yet, despite that, the reasoning of Mrs Justice Garnham in Yusuf is that Section 38, which is the right of access to the court, was sufficient, notwithstanding that armoured had reached the opposite conclusion. Certainly our submission is that armoured is very clear. There has to be a minimum level of judicial control so as to allow an effective challenge by the person concerned to their designation. And whether one uses it in the language of Lord Mance, I think it's Lord Phillips who uses the phrase effective challenge. But either way, that is the core reasoning in armoured. And if the Lordships consider that the court is not able to review in any detail the government side of the balance, in my submission that would not provide an effective right to challenge the reasons for treating the appellant.
It's not that we're not able to, but on well-established precedents, both in the Supreme Court and in this court, including my judgment, and also,
Yes.
we can review their assessment, but we give them considerable respect or weight, or how do you put a...
But if you're in the arena of special competence, but I think I've already made the point that...
No, that I understand. But suppose if you are in the right context, if you are in that arena, just because the courts of this country have held that while a decision is subject to judicial review, in other words, it is justiciable. Right?
Yes.
30, 40 years ago, the courts used to say these things are non-justiciable.
Yeah.
You don't say that anymore.
Yeah.
So, but just because we say, in addition, that a considerable respect or weight
Yes.
is given to the judgment of the executive, for example, in the conduct of foreign relations,
Yes.
whatever it may be. Why does that mean that there isn't effective access to a court, if that is the doctrinal framework in which a court operates in that context?
So obviously the sufficiency of the access depends upon the context. So I'm not going to pretend that there won't be cases where the context demands that there are parts of the decision making that are impenetrable to the court for whatever the reason is, special competence or institutional allocation of responsibility. But that has to be seen in the context of the individualised consideration that the
Yes.
court gives to balance. And where we are here in an area of individualised consideration where there is nothing mystical about the factors that are being weighed on either side, they're concerned with ordinary human behaviour and the assumption one can make about ordinary human behaviour. These are entirely within the purview of the court and within your ability to judge for yourselves.
Finally, can I ask you this on ground 4 of your appeal? If you're right on ground 4, would the remedy be a declaration of incompatibility vis-à-vis Section 38 or something else?
Well, I think Section 38 could be read down very easily.
Right.
Because the reference to judicial review principles is a phrase pregnant with uncertainty, and so one could very easily deal with that.
Do we have Section 38 in the budget?
Sorry, I realised it was missing, and I've got it here.
I was sure it must be about to come up. Thank you very much.
So it's 38.2, the right to apply for High Court, and then 38.4, as I say, court must apply the principles applicable on an application for judicial review.
I mean, those principles include whether there has been a breach of Section 6 of the Human Rights Act.
Yes, yes.
And so,
Yes.
and as we said in Dalston, judicial review for this purpose includes
Yes.
proportionality review
Yes.
by the court.
I agree, which is why we say Mrs Justice Cockerill must be wrong in saying, this overrides what's said by the Supreme Court about the rights of access to the court and Article 6. It clearly doesn't. That, I hope, concludes all I had to say, unless there is anything I can assist your lordships with.
No, thank you very much. Asked my lawyers, but they would have spoken up. Yes. Yes, Mr. Blundell.
Well, I'm grateful. Well, look, if the Solicitor Court, can I take things in 4 stages, and I'll outline what they are now, before going through them in turn. First, can I make some brief introductory submissions? I'll do 2 things when I do that, or attempt to do 2 things. One is to outline, at a very high level, the Secretary of State's case in a nutshell, and the other is to make some brief introductory submissions about the nature of the claim and some particular important factors to bear in mind. Secondly, against that background, I wanted to make, if I may, some brief, and they will be very brief because my learned friend's taking you to it, but brief submissions on the statutory framework. Thirdly, some very brief submissions on just one case, which is Dalston. Any other cases I'll go through as I go through the grounds. And then, fourthly, can I respond to the grounds as they've been put today? So, beginning with the introductory submissions, can I give you the Secretary of State's case in a nutshell, so that you can see where I'm going when I come to that stage? First of all, on ground 1, so Padfield, we say the court below did not err in its approach to Padfield. We say it was clear that the judge took what she termed, entirely, we say properly as well, particularly in a scheme of this nature, a prima facie view of Padfield propriety based on the statutory conditions for designation and the purposes of the legislation, but she then expressly held that such a view could be, as she put it, negatived by other material, and went on to consider the matter on the facts of the case. We say it is quite wrong to suggest there was either no individualised consideration, or that she refused in any way to engage with Padfield on a full and proper basis. She did. She simply noted it was a difficult argument. Ground 2, we say the learned judge below rightly found that Regulation 6.2d is compatible with Article 8 and A1P1. The reference, of course, to association in the regulation directly and precisely mirrors the empowering provision in Section 11.3 of SAMLA. But the mechanism, it's important to have regard to the entirety of it, the mechanism in Regulation 6, of course, provides a specific definition of association. It's not association bare and simple, but rather association by 2 identified means, either obtaining a financial benefit from an involved person or being an immediate family member of such a person. And the phrase immediate family member is then, of course, as the court has seen, further defined in Regulation 6.7. So the specificity of the regulation in my submission is important. When I come in due course to the cases like Gallagher and Bridges, the submission will be that, first of all, it's important when you're looking at it in accordance with the law to be clear about what it is that particular Strasbourg requirement or convention requirement is actually targeted at avoiding, and it is arbitrariness. It's the court saw this morning, that is the guiding principle that runs through Lord Sumption's speech in Gallagher and also appears in this court's summary in Bridges. And we say in assessing arbitrariness, it is extremely important to have regard to the full specificity of the regulation. Of course, as this court noted in Dalston and Schvidler, there is scope in Regulation 6 for association beyond those bare terms. So the association element against Mr. Schvidler was that he was a close personal and business associate of Mr. Abramovich. But of course, if that's correct, and we say it is, then the position here is a fortiori, where you have somebody falling within the precise scope. And we say the regulation provides sufficient guidance in a particular case to somebody to know that they are within that scope, and it is therefore foreseeable that they will be targeted with a sanction. In those circumstances, we say the foreseeability and accessibility tests are clearly met. And just for your reference, that passage in Dalston is paragraph 184.
It's the problem with trailing submissions. You make them in such detail that
I'm so sorry, going too fast. I'm sorry. Paragraphs 184 and 185 in Dalston. Sorry, I initially intended to be quite brief, but I thought it might be helpful for you, given the detail of the argument we have to meet, quite rightly, to give you the headlines in a little more detail than usual at this stage. You can see where I'm going as I go through. Ground 3, we say decision, or perhaps more accurately here, given this is the systemic challenge. The decision, and insofar as it's relevant to this process, is proportionate, and the judge did not err.
So you say, given that this is a systemic challenge?
Well, sorry, given that one aspect of this is systemic,
yes.
Because we face the proportionality in the broad sense, challenging human rights challenge both systemically and individually. We say she didn't err in her approach to that test. In fact, when you read her judgment in my submission fairly and in context, it is clear that she wasn't falling into the same error as Mr. Justice Garnham did in Schvidler. There's no dispute, of course, when the court comes to look at the substance. And again, I should say, of course, it's quite clear from this court's decision in Dalston now that ultimately it is for the court to make that decision on proportionality, and we obviously don't seek to challenge that in any way. And we do say this is a Category 3 case to meet one of the questions asked this morning. But no dispute that the impact in a case like this may well be significant. It is no part of my case to stand here and suggest to this court that the impact on Miss Khan and her family is nothing other than significant. It is.
Well, how about nothing other than extremely grave?
Well, there are different ways one can perhaps cut the point.
Well, significant is rather a weasel word, it can mean very little.
Well, it certainly wasn't meant to be a weasel word.
Sorry, I keep using that phrase, and it's more pejorative than I meant, but it evades, that's rude as well, it avoids...
I'm not trying to be...
We've got to recognise that this is the impact is incredibly grave.
Well,
it may still be justifiable, but to say that, oh, well, it's significant is an understatement.
Well, in my submission, not, with respect. And the reason I say that is this. It definitely is significant. I would even go as far as to say it is definitely grave. Beyond that, one has to be very careful. In reality, there's a number of different ways the case is put. Needless to say, there is, of course, clear and fair reliance on healthcare and education impacts. The court has seen the health issues. We don't obviously go behind any of that. We're not in a position to do that at all. We don't seek to do that. The healthcare issues are what they are. But when you come to looking at gravity of impact, it is the case that the bottom line here is that both there is state provision for healthcare and education. And I highlight those 2 points because that's where the bulk of the point has been put against me. There is a generic point as well about prison of the state and it all being very difficult. Of course, that's right. But for the key areas of difficulty, healthcare and education, there remains state provision and the licensing process. Now, there have been criticisms of the licensing process. Mr. Reid, in his evidence, gave some evidence about why, at the start of the process, became hopefully less of an issue later on. The court will have noted that the letter placed before you today, seeking a licence for school fees, related to an application made on the 26th of June and decided on the 2nd of August. So in my submission, it appears to be the case that certainly, in terms of timing, things
Well, that doesn't look great either. That's 6 weeks.
But my lord, in my submission, that's a perfectly appropriate time for a submission of that kind. And indeed, my lord, given that that would be at the end
When
of the
people need to make decisions about their
do.
lives, it's not very satisfactory to have to wait for a civil servant to decide for 6 weeks.
No, but the reason why a civil servant has to approach this very carefully, my lord, is because, of course, the civil servant has to get the decision absolutely right.
Of
And
course.
if the decision is wrong the other way, and in fact people are able to evade the full impact of the sanctions regime because licences have been granted when perhaps they shouldn't have been, and the sanctions regime is designed to have an impact.
You may have misunderstood. It may have been my fault. You misunderstood. It's not. It may well be justifiable for it to take 6 weeks for any particular decision. I don't know. My point is, in terms of the interference with people's lives, having to wait for 6 weeks, however justifiable from the decision maker's point of view, is still a grave interference.
I accept
that. Was the
the
emphasis of my point, not a criticism.
It was my fault, my lord. I misunderstood.
No, I think it was probably mine. But
No,
anyway, but that's we got off on all this because I didn't like your word significance.
Yes.
And
I was trying to be candid, but there we go.
Anyway, there you are. In a way, we've still got all the big questions to come, but I don't think it helps to understate the impact of people's lives.
Certainly, my whole point in outlining this point at the outset was to make clear that we don't underestimate that. And the 6 week impact, we entirely accept it is going to be significant, that there needs to be certainty around those points. But a decision maker needs to get it right. It is not an easy issue to have to resolve. There is often a great deal of evidence to consider, and the impact on the sanctions regime needs to be considered as well. The point is, and this is really the bottom line, with both those particular areas, the designated person has access both to full state provision and the licensing regime. This is not a case, and this is what goes to my lord's point about how grave it is or how significant it is. There may well be, in a case like Ms. Carr's, a significant change of lifestyle, and that is obviously grave or significant, however one wants to put it in itself. But the bottom line is always that where one is getting to is the continuation, at least of state provision, the same state provision that most people have to deal with: state education, state healthcare. This isn't a statutory regime that cuts back on the ordinary provision of those particular ways of assisting individuals.
But I think you've just got to bear in mind that, of course, for reasons we understand, in the context of the impact on the children, healthcare and education were both emphasised.
Yes, of course.
But another part of the case, which you will have to deal with, and I'll ask you to deal with it now, is the intrusion in anyone's life of being dependent on the decision of the government on every penny that they spend and on every gift that they receive and effectively on all the major decisions in their lives. That's grave, even if you were the kind of person who would only ever have used the health service anyway and would regard state education anyway.
Yes, well, we entirely accept that. And what was going to be the third of my short introductory submissions after the headline of the Secretary of State's case was precisely that. We don't dispute the serious impacts, but that's, in a sense, the purpose of a licensing regime. A licensing regime is intended to have an impact. A sanction without an impact is no sanction at all. The control, of course, ultimately lies, we say, in proportionality. And we fully accept, then, the individualised nature of the impacts and their gravity has to be weighed against the significance of the contribution to the purpose of the sanctioning that exists through the individual designation. So that was a leap, if you like, from ground 3 to ground 4, but I think I've covered my introductory points on ground 3 to my submission 3. Ground 4 is the new ground. Insofar as the court goes on to consider that, we say it doesn't go anywhere. Ultimately, the sort of regime in consideration in Ahmed is quite different. That was a regime where there was designation effectively by list, which applied automatically, domestically. And part of the problem was any kind of judicial review would not be effective in actually delisting somebody. That's ultimately the nub of the problem with Ahmed. Quite different here. If a judicial review succeeds, whether it's on proportionality grounds, and whatever degree of deference is accorded to the Secretary of State, the effect will presumably be to quash a designation, set it aside, I think, in the statutory language of Section 38. So a very, very different process. And of course, we've cited also in the skeleton argument the long line of case law, both domestically, Alconbury onwards, and indeed in Strasbourg, cases like Ali, noting that domestic administrative law systems are entitled to shape how they approach issues of access to the court where public law rights are concerned, and that commonly occurs. And of course, this court's decision in Dalston is also of assistance on that point, because as my lord made clear in argument with my learned friend, the long and short of it is that proportionality is a matter for the court. I've given you, against that background of the case in a nutshell, one short introductory submission about the nature of a sanction. Submission number 2, public interest justifications for making sanctions in the context of the Russian invasion of Ukraine, we say is of the very highest significance. In a sense, you see that from the submissions that were made below as well and are recorded in the judgment. The Russian sanctions regime is designed to influence an independent international state actor who has invaded a sovereign state and caused untold death and misery there. It is of the very highest weight and significance. Third and final short introductory submission, we say the assessment by the Secretary of State of the measures required to best influence that actor and the assessment in individual cases necessarily involves considerations of the highest state prerogatives, foreign relations, in the context of an attempt to re-establish international peace and security. That, we do say, we don't shy from this submission, is an assessment that the Secretary of State is uniquely well placed to make. Respect to be given to that assessment is therefore very weighty. I'm avoiding using the word significant now. Is very weighty on grounds both of institutional competence and democratic accountability. And we say there can be no proper criticism of the judge for recognising those matters as she did.
These are all introductory submissions. The time to debate them with you is later, is it?
That sounds like I should probably say yes to that. Yes.
No, it's helpful to have them up front, but I don't want to get into a situation where we're examining them with them and you're coming back to them later.
I will be, absolutely.
Okay.
I raise them now because the argument is detailed and we have a lot to meet. Can I just finally end then in the introductory section before I go on to the legal background with just 2 points of fact that are perhaps worth bearing in mind when we come to the various different issues as they arise on the grounds. For the first one, can I ask you to just, can I ask the court to turn up, please, read the Reed witness statement?
Yes.
It's in the confidential bundle, bundle X, behind tab 11. Let's go through it in great detail, but there are just 2 passages there that are worth seeing. The first is for this point, if you turn to page 332, and I'll explain what the point is. There was much made in argument against us about, in some sense, the historic nature of Mr. Khan's connection with President Putin and the Russian regime, and how that then plays into issues of proportionality, rational connection, and so on and so forth. Just to be absolutely clear, it is our case that that connection is alive and very strong. And again, important that there's no misunderstanding about that. Page 332, the 4th bullet point. You'll see 4 lines down, the FC, and I should say, this, although it's in the confidential statement, none of this is actually confidential material, so it's not blacked out in the other version.
Right, thank you.
So the FCDO notes that Mr. Khan is not designated solely on the ground of grounds suspected associated with Putin and so on. The SDF contains evidence of his association with Putin. In addition to the information contained in that SDF, I note that on the 16th of March 23, 16 days after Ms. Khan's request for revocation of her designation was refused, it was reported that Mr. Khan attended a meeting at the Kremlin hosted by Mr. Putin, President Putin, I should say. In this meeting, Mr. Khan, alongside at least 7 other individuals designated by the UK, was urged to invest in Russia's economy to mitigate the effects of Western sanctions and was discouraged from hiding assets in jurisdictions outside of Russia. His attendance at the meeting further demonstrates there continues to be a rational link to the objectives of the 2019 regulation, because it's evidence of his ongoing association, contrary to what's been suggested. We say that is important. It obviously very slightly postdates the review decision, but it's contemporaneous in the sense that it's showing the depth of connection. What's significant there is that this is somebody, who, of course, who has not challenged his designation, but this is somebody who was identified, in order to be at that meeting, by President Putin as an individual who was sufficiently significant to be portrayed in public as somebody being required to assist Russia by investing in Russia to mitigate the effects of sanctions, and specifically was discouraged from hiding assets in jurisdictions outside Russia. So we say that absolutely shows and goes to rationality of connection and ultimately fair balance as well in terms of the public interest side of the balance. Is specifically identified with relevance to the impact of the Western economic policy in terms of the war in Ukraine. The second passage is one you've seen briefly, but just again to flag it here. And again, this goes to demonstrate the continuing and very up-to-date nature of the economic relationship and financial benefit between the Khans. It's over the page 334. So letter D, there is a short passage of confidential material which I will not read out, and I'll indicate it when I get to it. But there's a concern there about mitigation of the impact by holding assets through or moving assets into the names of others, including Mr. Khan. We assess that the risk, and of course this is an assessment looking to the future in essence. The assessment is the likelihood of the risk materialising is increased by the pattern of past behaviour, specifically providing a substantial financial and other assistance. Mr. Khan provided her, and then the next bit is confidential, so the figure and the number. In March 2022, shortly before he was designated, designation will therefore reduce the likelihood that there's any attempt to circumvent the effect of sanctions on Mr. Khan, and in turn increase the likelihood that the designation of Mr. Khan has its intended effect. Bear in mind, of course, the position that Mr. Khan has been put in by President Putin, which I've just shown you. Now, Ms. Khan is entirely candid about that. She doesn't in any way hide that or seek to avoid it. You can see how she deals with it in her witness statement, which is behind tab 8, page 220. And this bit is dealt with at page 223. I just ask the court to read at the bottom of the page, paragraph 65, dealing with bit 14.
So which page are we on?
223, my lord.
Which paragraph?
Sorry, did I say 223? I meant 233. My apologies.
I was puzzled.
My mistake, I'm sorry. And it's paragraph 65. Of course, entirely accept at that stage that transfer was lawful, but it was made under the shadow of designation. And you've seen, as I say, the position that Mr. Khan has been placed in.
And you may or may not accept this, but it is said to have been a gift for her and her children's needs.
Yes.
Presumably,
Yes.
in light of the fact he might not win, never to give her in the foreseeable future to give her any more. So,
Yes.
I mean, if the implication is that this was given so that he would have access to a pot of money for his own use abroad, that's not what she says.
No, and it doesn't need to be. That doesn't need to be the implication that is drawn, because part of the purpose, precisely, of sanctioning or designating rather an associated person, is to place pressure on the principal or the player, as it's being put, precisely because of the designation of those close to them. And that might be because the person close says, as the court has noted this morning, well, this is just unbearable. The impact on me of these sanctions is absolutely terrible. I can't do anything. You have to use what influence you have. And by the way, look at what influence you do have to try and change things. Or because the person themselves takes that view quite independently. We say properly construed, the sanctions designation form is in fairly neutral terms about that. The point has been made, well, this is a point that really arises more through Mr. Reed's evidence. But we say actually that the form itself is fairly neutral as to how the influence arises. The point is that is an entirely rational and fair approach to take. And that goes back to the fact that sanctions will have a severe impact on individuals who are designated, perhaps particularly severe for those who are not directly involved, but it is precisely the using of an indirect lever that can be effective. And one might ask, rhetorically, what could be more effective for somebody who isn't involved, but in terms of putting extra pressure both on involved
Putting
persons,
pressure on an innocent person in order to get the guilty person to change their conduct.
yes, it's put in high terms, but yes. You're associated, if you're somebody who is involved because you are supporting an area of economic significance in Russia, as Mr. Khan is, and you've seen the evidence about it, there's no doubt whatsoever about that. And I think the Alpha Group is the 4th largest financial institution in Russia, certainly something of that nature, and you've seen the sums involved. Then the most effective way, and particularly one might think in a case like this, where Mr. Khan has left the country, but it may be a particularly effective way to leverage influence over him and therefore over the Russian regime to target the family. Harsh as that sounds, that's why I began by indicating we don't resile from the significance of the impact or the harshness.
Mr. Blunt, I understand that submission, but it seems to me that's a distinct submission from the point that you were showing us a moment ago at page 334, paragraph D, which then led you to take us to paragraph 65 at page 234. I'm not sure I fully understand what this distinct point is that's being made, because if Mr. Khan is a designated person,
Yes.
then, but Mrs. Khan was not, would he be able to transfer assets to her?
No, absolutely, and I don't suggest otherwise. The regime is as it is. He wouldn't be able, without, and she wouldn't be able to do it without the risk of criminal penalty. And you've seen regulations, I think it's 12 to 15 on how that works. But the purpose of sanctioning then, in particular, picks up moreover the indirect lever of influence.
Yeah,
Well, right.
I get that point. Yeah.
Yes, yes.
But if sanctions were removed in relation to Ms. Khan, then the sum of money which was referred to in March 22 would be hers
Yes.
to
yes.
deal with it as she thought fit.
Yes, it was transferred to her before either of them were sanctioned. So that's why I said at that stage that was lawful. It was carried out under the shadow of what looked like, and indeed was, imminent designation.
But my lord's point is, if he is designated, then she
can't deal with the sanctions.
she can't give him money, or she can't receive money from him.
No. It may be, though, and this is part of what one gets from letter D, in addition to the point about, well, it provides a different incentive for him, it may still be that there is a greater incentive, at least for Mr. Khan, to attempt to circumvent the effect of the sanctions regime by trying to pass money to her. But she will take a risk in accepting it. We entirely accept that. That's why you have a range of those matters. And just then on some of the factual points that were raised this morning, Melania Friend's quite right to say this afternoon that there is now a general licence for legal fees of £2 million. Just to give you a little more detail, there has been a general licence for legal fees since the 28th of October 2022. It was initially in the sum of £500,000, and it was increased in October of this year to £2 million. That, of course, did not benefit Ms. Khan at the time of her designation. but it has been in place since then. Her designation was in the April before that. There are also a number of other general licences, and perhaps what we can do is provide you with a full list of them. There are certain utilities licences, energy licences, and so on and so forth, but perhaps if we could, maybe a list we can agree between the parties, but perhaps if I could provide them.
Is Ms Montgomery right that there's still nothing in relation to daily living expenses?
Correct, that's right.
And why is that? I mean, the courts of themselves,
Yes.
I mean, I know we weren't very good at the start with freezing orders, but worked out you needed to have some designation to allow for living expenses. Surely the same should apply for a sanctioning regime.
Yeah. Well, can I come back to you on that?
Course,
Because I'm going
yeah.
to state, I understand the question of why it's put, but I will need specific instructions on why there isn't for that. We were able to get instructions on that.
I'm confusing myself, but just about two separate points. There's a general order which basically allows expenditure over a period of a particular kind up to a certain amount. Is that right?
That's for legal expenses. That's
Yes, all right. But I mean, conceptually,
Yes,
you're talking about general orders and specific orders.
Yes.
But one sees the advantage of general orders, so you don't have to go back
Exactly.
each week with your bills from Tesco.
You can just incur the expenditure. So for lawyers, you can simply consult a lawyer. And
Yeah, well, all right. But I mean, it's not so worried about lawyers. More worried about daily life.
Yes.
But there's a separate question which my Lord is particularly focusing on, which is that from the moment you impose the designation in freezing orders on individuals
Yes.
in the commercial sphere, from the day one, there is an estimate of, there is an allowance to spend so much, and that can be adjusted if it turns out to be unrealistic either way.
Yes.
But that doesn't seem to be in the system here.
No, it's not. In
Or is
practice,
that still not the system?
my instructions are it's still not the system.
But how is that possibly justifiable? Because you take away everyone's money
Yes.
and then say, we'll decide how much you can spend in once we've had an application from you.
So in practice, what happens while the application is pending is that somebody has to spend money they already have and then
What if they haven't got any?
self-report. Well, then there is a difficult position. They may need to seek assistance. They may need to ask for extremely urgent consideration.
But anyway, the money they already have, even if they have got, I appreciate most people have a bit of
Yes.
cash, and the kind of people who are designated here probably
And that's
keep
what
quite a lot
happened
of
here.
cash. One doesn't know that. They may use cards the whole time, but it doesn't matter. They've either got, and when we say cash, we do actually mean cash,
Literally
because
cash.
cards, your bank won't recognise. So, how can it be right in principle that you've got to break the law in order to eat?
Well, again, that's dealt with as a matter of practice. You are able to do
But
it.
that's
and
practice, not, you've got to risk breaking the law.
you have got a risk. I have to accept that. But the practice is, and it is borne out by this particular case, once you self-report, there is no action taken in those circumstances.
How do you know you ought to self-report?
I think that will be made clear when the designation is indicated, because you're told about the consequence of the designation.
Is
The
there
consequence is sorry, my lord.
sorry, just picking up my lord, is there a sort of handout like people get with a freezing order about explaining it?
There is some detail. Can I come back to my
Of
lord on
course,
that,
yeah.
Nicholas?
Yeah, speaking of myself, if my lords will forgive me, speaking of myself, I would find it helpful if overnight we could be assisted with that information. What in, as it were, in layperson's terms, would somebody be informed of when they're initially designated, and what steps they may have to take, including what you've described as self-reporting. And while you're taking instructions on all of that, I would benefit overnight if you could tell us what the period of time was in this particular case between the appellant's designation and when she obtained a specific license which would permit her to pay for food.
Yes, we'll do that. I'll do that, my lord. Can I come back to that all in one go and pick it all up at the same time rather than doing it bit by bit, as it were? So we'll come back to you on that. But those are the facts in relation to the legal provision, the provision for legal fees with the general licence. those are my introductory submissions. Can I go then next to the statutory framework and say I will take this very quickly because my learned friend's gone through it in some detail. If I begin with SAMLA, you'll have that in volume 1 behind tab 1. You've seen section 11, but section 1 sets out the power to make sanctions regulations. You'll see page 4 this is. An appropriate minister, subsection 1, may make sanctions regulations where they consider it's appropriate to make the regulations. And then C, for a purpose within subsection 2. So you'll see A covers all the A and B, and C between them cover the whole territory. You have UN obligations in A, other international obligations in B, but then for a purpose in 2. And 2 is a purpose if the appropriate minister making the regulations considers that carrying out the purpose would, and relevantly here, B, be in the interest of national security, or C, in the interest of international peace and security.
Oh, you're saying B and C, were you?
Sorry, C and D, I should say.
C and D, I would have
C and
thought,
D,
exactly.
yes. C, further a foreign policy objective of the government of the United
Yes.
Kingdom. Sorry, C and
See
D.
the right ones, yeah.
And those were the purposes for which the 2019 regulations were made. I'll come to case law in due course, but I just make 3 submissions at the start. Again, those are the high state prerogatives identified by Parliament, so not by the Secretary of State, but by Parliament, which I identified. They are matters in respect of which, of course, in making the regulations and then applying them, secondly, that the Secretary of State is uniquely well placed to assess. And of course, relatedly, thirdly, uniquely well placed to assess whether the designation of a particular individual will pursue the overarching statutory purpose. So that obviously goes to Padfield. The version of section 11, which was in force at the time of Ms Khan's designation, is at page 9 within the same tab. You'll see, compared to the version on the preceding pages, which existed before, subsection 2, as my friend indicated, has changed. You now have a section 2, the regulations must provide that under the standard procedure the minister is prohibited from designating a person by name except where condition A is met. And then condition A is that the minister has reasonable grounds to suspect the person is an involved person. Over the lunchtime adjournment, we had a look at the explanatory notes to the Economic Crime Transparency and Enforcement Act.
Oh, yes.
So that was the act which brought into effect that change. And the suggestion in those notes, and again, perhaps we can provide them overnight,
Yes, do, thank you.
is that this was done to speed up the process of designation effectively. So I think it's quite close, it is the point that my lord made in all. That doesn't mean, of course, and I say this straight away, that one doesn't have to comply with Padfield. One does, of course, in any individual case. But the particular consideration of appropriateness under section 11 is gone. Then you have involved person defined at subsection 3. So A is effectively the player. The principal is or has been involved in an activity specified. B is the association criteria, a member of or associated with a person who is or has been so involved. So again, Parliament...
B.
Sorry, D.
D.
D. Sorry, D.
I misheard. Yep. Yes.
So D is association. That is where association at its highest comes from when you get to the regulations.
Yep.
And you see an activity may not be specified. This is 4 in the regulations by virtue of 3, unless the minister considers appropriate having regard to the purpose in 3. In section 1.3. And then again, subsection 6, the regulations may make provision for the purpose of the regs as to the meaning of a person being associated with letter B. Don't need to go through the other provisions of the Act, you have them already. Then you're into the regs behind divider 2. Perhaps just before I get to the regs, I did make the point, I emphasised the point as I went through just now, that the associated with criterion is one that's identified by Parliament. And bearing in mind we face a systemic challenge here, both in terms of accessibility and foreseeability, the in accordance with the law point, and indeed generally with regard to proportionality, we say it is relevant that it's Parliament that's considered that the association criterion is necessary.
Well, that's true, but the sting is in the definition of associated. If associated meant only had been defined purely as a spouse, say, might still be points, but there would be very different kinds of points from the ones that have been made here.
Well, perhaps, although of course the real bite of the provision with this case is precisely a spouse. Spouse and financial benefit, of course, it's both.
Yes, but anyway.
Yeah, you have to. We very much say, and I'm not. This isn't a case where I'm saying, well, you look at what Parliament has said, and that's the answer. That's the beginning, the middle, and the end. This is a case where you absolutely have to go to the regulations.
Yeah.
But the regulations, and let me headline this point: the specificity in the regulations, in my submission, assists the Secretary of State. So specifically, when dealing with the in accordance with the law point, we do say that the measure, the designation in question, when you look at what the scope of application is, we say it is adequately foreseeable. It is.
Well, this is the point you've just made, but I didn't ask you any questions about because I was told you were only trailing the point. Maybe you're still trailing it, but surely Ms. Montgomery's point is not that the classes of people who can be associates isn't specific. It is. But it's because the class is so very wide, not only lots of different kinds of family members, but also, even if you just looked at spouses, there will be an incredibly wide variety of circumstances. And if there's been tended to be a discretion as to which kinds of associates you are going to designate, there's no way of knowing who they are.
Well, the control then, in my submission, and having trailed it, I don't think I can avoid answering the question which I was doing before, but the control in that situation is to look at two things in my submission. First of all, there's the point that the real issue with foreseeability is the avoidance of arbitrariness. And part of the control, secondly, for avoiding arbitrariness is the fact that in all cases, there is a consideration, a full consideration of proportionality. And that's the case even if ECHR rights.
Well, let's. Okay, I couldn't resist. As you can make that point properly when you come to it. But I'm slightly rebelling against you rubbing our noses in the fact that we know that you have to be a sister or an uncle or an aunt or whatever it is. That's not the point you're meeting. But you have an answer to the point you're meeting, but it's not that one.
No. But having been asked it, I thought it best to give you just the headline of it now.
Yes. Okay. Right. Carry on.
So you get then the nub of it, as I say, the nub of it is to look in the regulations. Now you get the purposes for the regulations set out squarely in Regulation 4. That's at page 18. So encouraging Russia to cease actions destabilising Ukraine. My friend said, and I agree. The second one, of promoting payment compensation, not really relevant yet, but maybe in the future. That, of course, those purposes pick up on the purposes in Section 1.2 of SAMLA of International Peace and Security, and further in the foreign policy objectives. That is the application in the specific context of Russia and what's happening in Ukraine. You've got the general provision in SAMLA, you've got the specific application to Russia here. And we say when you look at the sanctions designation from the SDF, those are the purposes identified. Then you have, skip over 5, you then have designation criteria in 6. of course, you've been through this already, but the Secretary of State may not designate unless he has reasonable grounds, that's 1A, suspect the person is involved, and considers the designation is appropriate having regard to the purposes in Regulation 4 and the likely significant effect of designation on that person. So the regulation identifies effectively the Padfield requirements and the concern about impact which to feed directly into the human rights proportionality assessment.
Hang on, I've just noticed this is version 6 of 6, 31st of July 2024 to present.
Yes.
Should we not have the version that was in force at the time of the decision? I dare say there must be some difference, or it would be a different version.
Yes. Can we provide
Just for
those
form's sake. Yeah.
Yes, I'm sorry.
But am I being slow? Maybe because the time in the afternoon. But has the criteria that were taken out in the statute in the original 1-2, that's the original 11-2, have come back in, aren't they? Aren't they the same as
Yes,
6-1?
Well, they haven't been deleted, but they cease to have effect
Exactly.
by virtue of Section 61. So they remain in the regulation, but they have no effect because of Section 61 of the Economic Crime.
and that's in the next tab.
Oh, I see.
So
Particularly helpful way of putting together legislation.
exactly. So Westlaw
Yeah.
will still show it as in effect, but unless you go to the 2022 Act where you can see.
Oh, extraordinary.
And that's at page 37. So it's still there, but 37.
Oh, well, at least it shows I was on the ball. Anyway, there we are. Everybody seems to know, but it is an odd way of doing it. Right.
Well, as we're there, perhaps if you can turn that up, it's at page 37. You'll see it's subsection 1.
Have the editors of Westlaw been told to put in a note?
I'm sure they will be.
It actually, I mean, it is seriously misleading. Because if you were just looking at the regs, which is the place you'd expect to go,
You can't find it.
you wouldn't know that they were not inoperative. I think somebody might think about that. But it's not so difficult to change regs.
No.
Okay, well, there we are.
No.
So it's Section 61.
Yes, section 61 is what gives you the answer, and that's why you apply it.
Yes, okay, but so which 61.3 is it?
61.1. So you start at 61 exactly, and then you go down to 61.3 exactly. So any pre-commencement regulations which authorise appropriate ministers to designate by name have effect for the purpose of doing anything after the passing of this Act is deemed to have always had effect. And so
It's not even very clearly expressed, but I see. If you read it carefully, you can see what it means.
exactly, and then 3A, you get the reference to section 11.2b. So it is a bit of a paper chase,
Yes.
but that's the effect.
Right. Well, if you're not going to be much longer on the regs, we may as well finish them. But
Yes, I can
we'll be
finish
looking
those.
Sorry?
easily too. Yes, absolutely. So then you see involved person in 2 means a person A involved in destabilising or, and then the provision which is relevant to Mr. Gon, obtaining a benefit from or supporting the government of Russia. And then D is the association provision. So again, it replicates section 11. You get further detail of being involved in destabilising the Ukraine paragraph 3. The reference to financial services at C. And then 4 over the page is the relevant one. For the purposes of this regulation, being involved in obtaining a benefit from or supporting the government of Russia means, and then you can see.
well, we've seen all this.
Seen
What
all
are the
of
particular points you're taking us to the
Now,
before?
just finally, just to give you, again, because it's relevant to the specificity point, 6 is association subdivided into financial benefit or immediate family member and immediate family
Well, again,
member.
we've seen all that. So
So the submission is going to be, and you've already had it in a headline,
it's all very specific. Yeah.
there, exactly.
Despite my telling you that wasn't really the real point. Yes. So.
You don't need to go to the provisions of the 2022 Act because you've seen the relevant one, which I was going to go to, which is section 61.
Right. So that's what you wanted to say to us about the legislation.
Exactly. The next stage would be Dalston very briefly, followed by the 4 grounds.
Well,
Is that a
that's
convenient
a
moment?
sensible place to break. You're being customarily succinct. Mr. Blundell, I don't anticipate there will be any difficulty finishing in time for reply, in time for lunch?
No. And I'll review my notes overnight, see what I can put down.
Yes, it's an important case. Don't feel under time pressure, but succinctness is always appreciated.
Noted. I'm grateful.
Yes.
There's just one issue in this confidentiality issue, which was made by the master. It seemed to be trying to raise it by the whole. The figures, for example,
Yeah.
is not. We're not allowed to say, but in fact, there's no good reason for that.
Yes.
Can I
Well,
actually-
why don't you just make the point?
just on the confidentiality schedules, chasing down the orders. Obviously, the orders were made by the court effectively on the application,
Yes.
and were to ensure that the confidential matters weren't just allowed to be searched
Yes.
for very good reason. No one thereafter seems to have revisited the point about whether there should be any transparency in any of the issues. Now, issues like medical information and details, everyone would understand. But, for example, figures about gifts,
Yes.
at the moment, one might consider that there's a good reason to revisit that and to have that publicly available. But obviously, no one could do that without giving everyone a fair opportunity to consider the point.
Yes. Well, I mean, obviously, one of the reasons for sensitivity about gifts, particularly some of the art, is that there have been real concerns about the security.
Yeah, I've seen some of the materials on that, but on the other hand, aspects of the size of a financial gift, which is now frozen and not available, might be considered to be material to a court's judgment in this, where the interests of the public in knowing about the information outweigh the proper individuals' concerns about confidentiality. I just raise it because it's something that needs to be...
I recognise that. I mean, clearly there'll be a spectrum, but the concern is obviously, particularly if this appeal fails, in protecting those assets that are identified from being subject to attack.
Yeah.
Well, one possibility, this is me thinking aloud, which is perhaps not a sensible thing, would be if, when we come to write our judgments, we take the view that certain matters in the confidential do not, on the face of it, deserve protection, we will include them in the judgment with perhaps a note to counsel to say that we will need to have them justified if you want to preserve the confidentiality.
That seems...
rather than do it in the abstract, you could spend a lot of hours quarrelling about this paragraph or that paragraph, and when we were never going to refer to it anyway.
Yes.
So
if we
just
have,
a thought.
If we
I
have
think
liberty
you ought to
to
start
apply,
thinking now.
if we have liberty to apply on that basis, that would cover it.
Well, you see a draft judgment.
Yes, it wasn't really liberty. I was envisaging that maybe we'd give you an extra day for it, but broadly speaking, when you get the draft judgments in the usual way, instead of just talking about with typos and factual things, you could say in paragraph 46, this is mentioned.
Yes.
Yeah.
Yes. But if your lordship hold the ring till then, that
Probably the best way forward. If either you or we have further thoughts tomorrow morning, we'll communicate them. 10:30 tomorrow. Thank you.